On a Tuesday afternoon in late autumn, something happened that few people were paying attention to. Not because it wasn't important, but because in this moment in American politics, we've become almost numb to the extraordinary. A filing appeared, not in the pages of the New York Times or the Washington Post, but in a federal courthouse, quietly, methodically. The kind of document that doesn't move markets or break the internet, but should. Here's what most people don't understand. The way power operates in America, especially when it's under scrutiny, is not always loud. It's not always visible on your television screen or your social media feed. Sometimes it moves through the courts, through filings, through the careful, deliberate work of lawyers who understand that words on a page, the right words, in the right legal framework, can reshape the entire landscape of what's possible. This particular filing was different. It wasn't just another motion in a long list of motions. It represented something more fundamental, a strategic choice, a calculated move by someone who has learned over the course of years how to use the legal system not just defensively, but offensively. Now, before I go further, I want to be clear about something. In American democracy, the courts are supposed to be above politics. That's the theory. That's what we teach in civics classes. That's what we tell ourselves when we need to believe in something bigger than the daily chaos. But the courts operate within a political reality. They operate within a world where the President of the United States or someone seeking to be president has certain powers, certain constraints, and certain vulnerabilities. And when you understand how those three things interact, you begin to see the chessboard clearly. This filing was a move on that board. Most people, if they saw it at all, probably thought, oh, another legal action, another lawsuit, another thing to worry about. And then they moved on. They had jobs to attend to, children to raise, bills to pay. But here's where it gets important. Here's what you need to understand about how the American system actually works, not how we pretend it works. This filing in many ways changed the game. To understand why this matters, we have to zoom out for a moment. We have to think about what's actually at stake here, not just for one person, but for the entire structure of American governance. When we talk about the stakes in a moment like this, we're not really talking about winning or losing a particular case. We're talking about something much deeper. We're talking about precedent. We're talking about power. We're talking about the boundaries of what a president can and cannot do. For decades, there's been this understanding, unwritten but real, about the limits of presidential power. Yes, presidents are powerful. Yes, they have authorities that other citizens don't have. But there are lines, there are constraints, there are things that even a president cannot do without facing consequences. This filing was essentially asking a court to move one of those lines. Now, let's be precise about what that means. The argument wasn't crude. It wasn't someone standing up and saying, presidents should be above the law. The arguments are much more sophisticated than that. They're about the nature of presidential immunity. They're about what constitutes official acts. They're about the proper scope of executive power when national security is involved. These are serious legal arguments. Arguments that have been made before. Arguments that scholars debate in law schools and academic journals. But here's what most people don't realize. The outcome of this particular case could reshape what presidents can actually do and, more importantly, what they can do without facing legal consequences. Think about that for a moment. Think about what it would mean if a court ruled that a president, any president, not just this one, had the authority to take certain actions that were previously thought to be off limits without fear of prosecution. You're not just talking about one case. You're not just talking about one president. You're talking about fundamentally altering the relationship between the presidency and the law. And that affects everyone. It affects what Congress can do, because they may lose their oversight authority. It affects what the Justice Department can do, because their independence might be compromised. It affects what citizens can expect from their government. But here's the thing that keeps being missed in most of the coverage. The people who filed this know exactly how consequential this is. They're not accident prone. They're not making this move without understanding the implications. This is strategic. This is deliberate. This is someone using the legal system the way it's designed to be used as a tool of power. And the question isn't whether they'll succeed. The question is, what happens when they're forced to explain what they're actually asking for? Here's what most legal observers have noted, but what hasn't quite penetrated the public consciousness yet. This isn't just another case working its way through the system. The machinery that's been set in motion is significant. First, understand the timeline. Courts don't move quickly. They move deliberately. And that's by design. The judicial process is supposed to be careful, methodical, grounded in precedent and principle. But there's a political reality happening alongside the legal one. The filing triggers several things almost immediately. Other parties, Congress, the Justice Department, various advocacy groups now have the right to file their own responses. They'll submit briefs, they'll marshal legal arguments, they'll point to precedents that either support or undermine the core claims being made. In some cases, what you see happen is that these briefs become public windows into how different institutions actually understand their own power. What you learn is that sometimes people in government, serious people, people with authority, actually disagree profoundly about what the Constitution allows. Now, here's where the machinery gets complicated. Because this case, depending on how it plays out, could end up at the Supreme Court. And if it does, that changes everything. Because the Supreme Court doesn't just resolve disputes between two parties. The Supreme Court sets precedent. It shapes what the law means for the entire country. The lower courts, the district court, the appellate courts, they operate within a framework where they're trying to interpret existing law as faithfully as they can. But the Supreme Court has a different function. The Supreme Court can change what the law means. And here's what political observers understand. Supreme Court decisions about presidential power don't stay in a courtroom. They echo through the entire executive branch. They shape what presidents believe they can do. They shape what attorneys general believe they should allow. They shape what Congress believes it can oversee. This filing is essentially asking the courts to answer a question that has hung over American democracy for centuries. How much power does the presidency actually have? Previous courts have grappled with this. They've answered pieces of it, but rarely does a case come along that asks the question so directly, in such stark terms. And the people who filed this know that. They understand that they're not just arguing about their specific client, they're arguing about the nature of power itself. The legal machinery will grind forward. Briefs will be filed. Oral arguments will happen. Decisions will be written. And somewhere in that process, America's understanding of what a president can do might fundamentally shift. That's what's at stake. Now, let's talk about what actually happens if this works. And I mean if it works, if the courts rule in the direction that this filing is pushing. The immediate implications are clear, and they're significant. You'd see changes in how the Justice Department operates. You'd see changes in what legal exposure a president actually faces. You'd see changes in what Congress can investigate. But the deeper implications are more subtle. They're about the slow, gradual reshaping of American governance. Think about institutional behavior. Institutions learn. The FBI learns what they can investigate. The Justice Department learns what they can prosecute. Congress learns what kind of oversight is actually possible. Career government employees learn what they can object to. If a court rules that presidential power is broader than we thought, particularly around questions of national security, executive privilege, or what constitutes an official act, you don't just get a one-time change. You get a cascading effect. Institutions will adapt. They'll operate differently. They'll accept as normal what would have been considered unthinkable before. Here's a concrete example. Let's say the court rules that the president has broader authority to manage classified information, or to determine what's classified, or to decide what's in the national interest. That ruling doesn't just apply to one person. It applies to every president going forward. It becomes the new normal. And here's the thing that keeps me up at night about this. These kinds of changes don't usually provoke a response. They don't cause massive public outcry. They happen quietly, almost invisibly. A ruling comes down, the executive branch adjusts, life moves on. But cumulatively, over time, what you get is a fundamental shift in how power is actually distributed in American government. The founders worried about this. They wrote extensively about the dangers of unchecked executive power. They built in checks and balances. They made sure that Congress had investigative authority. They made sure that the courts had the power to limit executive overreach. But all of those checks and balances only work if everyone agrees that the other branches have legitimate authority to use them. If a court rules that the president's authority is as broad as this filing suggests, you're essentially saying that those checks aren't as robust as we thought. You're saying that Congress's investigative power might be limited. You're saying that the courts themselves might have less authority to oversee executive actions. And that changes everything about how American democracy actually functions. The people who filed this brief, they understand this perfectly well. They're not naive about what they're asking for. They're making a calculated bet that the courts will move in their direction. And they're betting that even if the courts move only partially in their direction, it's enough to reshape the landscape. That's the real game being played here. So what happens now? What should we be watching for? First, understand that this is a long game. These cases don't resolve quickly. You're looking at months, possibly years, of legal proceedings. Briefs will be filed. Arguments will be made. Decisions will come down. Appeals process will begin. During that time, the political landscape will continue to shift. Elections will happen. New administrations will come to power. New crises will demand attention. And all the while, this legal machinery will be grinding forward in the background. That's actually important because it means this case will be shaped by circumstances we can't predict. By the time it reaches a final decision, the world will have changed. New facts will have emerged. New political dynamics will exist. But here's what we should be watching for in the immediate term. Pay attention to how Congress responds. Do they file briefs? Do they investigate? Do they try to legislate in response to what they're seeing in the courts? Congressional response or lack of response will tell you a lot about whether the political will exists to actually defend institutional authority. Pay attention to the Justice Department. How do they argue the case? Are they arguing vigorously against the filing? Or are they somewhat lukewarm in their response? The Justice Department's position can shift with administrations, and that shift itself is revealing. Pay attention to the media narrative. Right now, this is being covered by legal specialists and political junkies. But if this case gains public attention, if it becomes a major story, the political dynamics shift entirely. Public pressure matters. And finally, pay attention to what other actors do. Do other countries use this case as evidence that American democracy is weakening? Do international partners question American commitments? Do investment markets react? These external pressures can shape how seriously courts take these questions. Because here's the thing about democracy. It's not just a set of rules written down in a constitution. It's not just a legal system. It's a set of shared understandings about what's acceptable, what's normal, what's off limits. When those understandings start to shift, when the courts start to move those lines, you get a cascading effect. Other actors adjust their behavior. Institutions change how they operate. What seemed unthinkable becomes routine. This filing is one moment in that longer process, but it's an important moment. It's a moment where the question of what presidential power actually means is being asked in the most serious forum we have. And the answer we get will shape American democracy for generations to come.